Hello everyone, welcome to Management 413 Employment Law here at the UAB Collat School of Business. In this video we will be covering the concept of downsizing, and we will look at some issues that arise after termination of employees using Chapter 19 of our textbook. The term downsizing is not a legal term, but actually is a nice way to describe the involuntary termination of many employees, usually at about the same time. Sometimes the term reduction in force is used to describe a downsizing. There are several laws that might restrict an employer's ability to do a downsizing or reduction in force. Several would arise for a unionized employer under the National Labor Relations Act. For example, downsizing in the middle of contract negotiations might be viewed as an unfair labor practice. Downsizing might be written into the agreement between the union representing employees and the employer as a mandatory topic of bargaining. Even if you are unionized, you can choose to go out of business entirely, but the National Labor Relations Act would say that you cannot selectively close facilities in order to inhibit unionization. For example, you would not be able to shut down factories only that had active union organization efforts underway. There's another federal law called the WARN Act. That is an acronym for Worker Adjustment and Retraining Notification Act. There are some very detailed provisions for when that law goes into effect that we will touch on here, but the thrust of the WARN Act is that employers may not order plants to be closed or layoffs to occur until the end of a notice period. The law only applies to larger employees. You can see here that the rule is in most cases that it applies only to employers with 100 or more full-time employees. There can be disputes over exactly how many employees, how many full-time employees a company might have. There can also be disputes over the measurement of the notice period, particularly if layoffs might occur in waves. There are two concepts in the WARN Act that would both require some notification. Plant closings would require some notification, and there is a different standard here for the number of employees an employer would have to have for notice of a plant closing. And there is also a concept of mass layoff, which, as you can see here, only applies if there are at least 500 full-time employees at a single work site that would be affected. Case from Alabama in your textbook. Please look at this and make sure you understand. It gives you a flavor for how the law works. A Greyhound racing track in southeast Alabama laid off all of its employees without giving them notice, and the employees sued. You can see the result here was that the court felt that the WARN Act had been violated. Layoffs and reductions in force, like many employment actions that we've seen earlier in this course, can lead to charges of illegal discrimination. A genuine reduction in force applies across the board without regard to anyone's protected class characteristics. If a reduction in force is used as a pretext, however, for illegal discrimination, for disparate treatment of someone or some group of people in a protected class, litigation can result. And one way that employees will try to prove that would be to show that immediately after a so-called reduction in force, someone else who was not in the protected class was hired to take the same job as the person who supposedly was laid off because her position or his position was not necessary at all. That was the case in this Gucci case on page 734 of the textbook. Of particular concern in a downsizing would be age discrimination because I'm sorry to say, usually the people who will suffer the most in a downsizing will be those who are over 40 and who have a more difficult time than younger people finding new jobs. Take a look at the case in your textbook, Barnett versus PA Consulting, where the court held that the termination of at least one employee in a downsizing was really a pretext for sex discrimination, illegal disparate treatment of someone based on gender. And one evidence of that was that the reason given for selecting that employee for the downsizing was the very nebulous lack of fit. Here are the elements of a claim that you would have to prove if you were to allege illegal discrimination based on age as part of a reduction in force. Another way that the age discrimination laws would apply in a downsizing would be if an employer decides that it wants to put in place a mandatory retirement plan. The Age Discrimination Act prohibits that, says you cannot mandate that someone retire. There is an exception for bona fide executives. They have to be at the very highest levels of the company. Otherwise, you may not require that someone retire at a particular age. There's another federal law that would govern if you tried to have an incentive program. You weren't mandating that people retire, but you were trying to incentivize them. The Older Workers Benefit Protection Act, which we have discussed at least once before in this course, would say that it is legal for you to have an early retirement program, but you have to be careful in how you structure it. You have to make it available to everyone above a certain age. You can't, for example, make it available only to people between the ages of, say, 52 and 56, but not for those who are older than 56, because you might be hoping that those who are older than 56 will want to retire anyway without getting an incentive. Everyone over a certain age that you choose has to be included in the program, and employees have to be informed if early retirement incentive plans are under serious consideration. What's the effect of a bankruptcy on employees? Employees are not secured creditors. They don't have a guaranteed right to wages after a business files for bankruptcy, but wages that are earned after a filing have a high priority. Wages earned prior to the filing are somewhat weaker. Union employers may ask the union for concessions if they have filed for bankruptcy, but just the mere fact that they have filed for bankruptcy does not entitle an employer to get out of its union contracts. Unemployment insurance is another post-termination issue. Employees who are involuntarily terminated and are able to look for work and are actively looking for work are probably eligible for unemployment insurance in each of the 50 states. There is an exception if you are discharged for misconduct or if you quit. This is very important. If you voluntarily quit, you are not eligible for unemployment insurance. You also have to show an attachment to the workforce, means that you have to be willing and able to accept suitable work. You can't be too picky. Again, if you have been discharged for misconduct, you are not eligible. However, the usual rule is that the misconduct has to be very serious and intentional. If you quit, you're usually not eligible. However, if you quit because you've really been constructively discharged, a concept we talked about earlier in the course, you may well be eligible for unemployment insurance. Employees who leave because of health hazards also might be eligible for unemployment insurance, even though they technically quit. Employees who go on strike at a unionized employer are not eligible unless the employer says they have been replaced and no longer have jobs. After employment, some issues can arise if The employee who has left has made certain agreements with the employer before leaving. Some examples of these would be non-compete agreements that we'll talk about in a second, agreements that say employees will not disclose trade secrets, agreements that say employees after they leave will not solicit clients of the former firm. These are all post-termination issues that are very important. Non-competition agreements are very carefully examined because they restrict a person's ability to earn a living. And public policy is that everybody should be able to earn a living. So the general rule of thumb is that an employer should only use a non-competition agreement if there is a very important business interest at stake and the terms of the agreement, such as the length and the geography of the agreement, should be very narrowly tailored. Take a look at the simulation for Chapter 19. It's question 11, where a mechanical engineer signed a non-compete agreement with her former company, but then left and formed a new company that competed with her former employer. Should she be allowed to do that? Non-solicitation agreements are treated slightly more positively by courts because they are not quite as restrictive in the departed employee's ability to earn a living. This is a picture of the movie Glengarry Glen Ross, where Alec Baldwin is playing a very harsh, aggressive. Finally, trade secrets. Many restrictive covenants that are entered into by an employer with an employee while they are employed that go into effect after the employee leaves are designed to protect the information that is considered a trade secret to the company. The secret formula for Coca-Cola, not that any employee of Coca-Cola has that, but the courts have recognized that employees have a common law duty not to divulge trade secrets. However, if the period of being restricted from using the trade secrets is too long, as was the case in Nanomech versus Suresh in your textbook, the court will refuse to enforce it.